expressed on the following sponsored program are strictly those of the host, guests, and callers, and not necessarily those of this station, its staff, management, or sponsors. Welcome to the South Florida Family Law Show with attorney Sean Shepard. Sit back today as attorney Shepard shares his vast family law experience. Attorney Shepard has 18 years in the area of family law. He has handled thousands of cases and hundreds of contested trials before both judge and jury. He is here every week to educate you on your rights and to answer your questions pertaining to family law. If you have a question regarding family law, call attorney Sean Shepard toll free at 888-565-1470. And now, here's attorney Sean Shepard.
Good afternoon, everybody, on this Friday afternoon. Happy to have you with us here. Again, I encourage you to call in. Going to have a good show today. Going to be talking about a few things, the nuts and bolts of filing family law actions here. If you have a question, as I always encourage you to do, doesn't need to be a question for yourself, could be for a friend, could be for a family member who's involved in some type of family law matter. Call in. There's no charge for the call. We'll answer all your questions here and look forward to hearing from you. Building on what we spoke about last week, I'm going to talk today for a little while about the actual filing of petitions for divorce and paternity and separate maintenance. A lot of people are in different types of situations. Of course, they've been married, they're seeking divorce. They've never been married, but they have children in common with other people and they want to bring a paternity action. Or they're married and they don't want to get divorced, but they want to receive support and other entitlements, and there's a thing called a petition for separate maintenance. I'm often asked the question, is there such a thing as legal separation in Florida? There's no recognized legal separation in Florida. You're either separated or not from a physical standpoint, but for those of you out there for any number of different reasons, financial or otherwise, who are married to somebody who perhaps it's health insurance reasons, perhaps it's other financial reasons, you don't want to get divorced for one reason or another. Most of the time that situation comes up in terms of health insurance entitlements and things like that, where one party in a relationship is in need of health insurance benefits, and if they become divorced, they lose their benefits or are just entitled to short-term COBRA benefits or some kind like that. And the parties don't mind remaining married to one another for those purposes. But they still want to have some structure to the relationship and be ensured that they're going to receive financial support from the other. There's a thing called a petition for separate maintenance. So anybody has any questions about that, feel free to call in as well. But there is a vehicle out there for being able to secure your rights of spousal support and other financial support from another party through a petition for separate maintenance. But mainly the two issues that I get called about most are divorces and paternity actions. Both are very similar in regards to the petitions you file. I always encourage people to confer with attorneys and competent counsel before filing any petition. There are two important aspects to your case, more important than any other aspect of your case, and they're called the file and the trial. The file is what you file with a court in order to ask the court what you're looking for. And in all the family law cases, what you file is called a petition. You may hear in civil arenas, the civil courts, there's a thing called a complaint. What they call it in family court is a petition. It's the same thing, though. It's your complaint to the court, what you're asking for from the other party. One of the first things you need to understand in filing any petition in family court in Florida is that you need to have a residency requirement before you can file. You can't simply just move to the state of Florida and the next day file a petition for divorce or a petition for paternity or other family law relief. What the court requires here in Florida is that you, before you file your petition, that you be a resident of the state of Florida for at least 6 months prior to filing your petition. So if you just moved here, you moved here 90 days ago, or you want to file a petition and you've lived here less than 6 months in the state of Florida, you have to put that on hold. You have to wait 6 months and be a resident in the state of Florida for at least 6 months prior to filing, so keep that in mind as well. If you file before the time required to be a resident, your petition will be dismissed. Well, it's one of the questions asked at every divorce trial, whether it's contested or uncontested, is have you been a resident, continuous resident in the state of Florida for at least 6 months prior to filing your petition? So that is a requirement, and keep that in mind. If you haven't been, you're wasting your money by filing. A lot of people move into state and due to domestic relations or otherwise move out of another state and move to Florida. Make sure that you meet your 6 months residency requirement before you file. There are states different from Florida. Florida is a no-fault state. And what that means is there's no requirement to prove to the court that there's any circumstance other than you have irreconcilable differences with your spouse in order to obtain a divorce. Some states have fault requirements or separation periods of 12 months, 18 months or more. Florida doesn't have such a requirement, but they do have a 6-month residency requirement before you can file. Filing the petition for divorce, I'll go through divorce first. Things you should expect when you have to file for divorce, and again, I encourage you to seek counsel before you file. Your pleading, your petition for dissolution of marriage, has to include every prayer for relief that you're asking for. It's one of the most important aspects of what you do in a divorce case, and you definitely want to seek counsel if you're unfamiliar with what to ask for when you file for divorce. The file and the trial are the two most important aspects of your divorce case. What you file and ask for is important, and certainly the trial, when it comes to it, if it's a contested trial, is another important part of the case. Everybody in Florida has a right to represent themselves in any court in Florida, including divorce court. Although I strongly discourage you from doing that, certainly, financial and other reasons may prohibit you from hiring an attorney to represent you. I've seen a lot of situations arise in this day and age, in these times in particular, being a financial stressor on everybody. A lot of people don't have money to hire an attorney. A lot of people don't have money to put down a retainer or to pay an attorney to go to what accumulates to a lot of pretrial hearings, a lot of case management hearings. Mediation is required in every court here locally in the Tri-County area. In Palm Beach County, for instance, you can't even get a temporary needs hearing without going to mediation first. And every court here in the Tri-County area requires mediation before you go to trial. What I've seen a lot of people doing is having a hybrid situation where they seek counsel before they file their petition. They find out what they need to include in their petition. They pay an attorney to do that for them. They file it pro se, which means they file it on their own. They proceed through the case representing themselves, and then when it comes to trial, if it remains a contested matter after mediation and it's unable to be resolved, they hire an attorney to try the case for them. Some attorneys don't handle that type of representation because they want to handle a case from start to finish. I take on representation of that kind all the time, and certainly it's of vital importance to have an attorney representing you, particularly at trial, because there's a lot of rules involved, evidentiary and otherwise, that you need to be familiar with when you go to a trial. And certainly representation by counsel at trial is necessary. So if you have a situation that prohibits you from being able to afford an attorney throughout the entirety of the proceedings and you want to try to save some money on the process, you have an absolute right to represent yourself. You have an absolute right to retain counsel whenever you'd like in the process. And with all that said, if you have the means, this is certainly a life-altering event in your life. Any divorce, regardless of the length of time, if it's contested, and particularly if it involves children, it's a crucial part of your life, and it's something that you certainly should have legal counsel representing you. But I understand there's situations where that's not possible. But keep in mind, the file and the trial are the two important aspects of your case, most important to the outcome of your case. Filing a petition for divorce is simply your demand to the other side of what you want. There are forms that you can obtain from the clerk of court. There are forms you can obtain online that have a check-the-box type of format and blank lines for any narrative paragraphs you want to include. They're pretty easy to follow. And of all the different aspects of legal work, divorce work has probably the highest populated amount of forms to use because of the number of pro se litigants involved in that field. So if anything were made to allow a pro se litigant the best chance of being able to fill out the paperwork on their own, I would say divorce work is on the top two. But filling out that paperwork remains very important. A lot of people fill out the paperwork and they fill it out with an eye toward things resolving. And they may fill it out and think to themselves, well, I think we can resolve a lot of issues, so I'm not going to include those in the petition. So I'm only going to include these things that I want to talk about, and I'm not going to include the others. A huge mistake in that regard. You never know how a case is going to proceed in litigation. You can have a situation where one party files a petition, leaves out particular aspects to the petition, personal property, equitable distribution of personal property, alimony claims, attorney's fees and cost claims. Definitely want to include, when you file your petition, everything you could possibly ask for in the petition, because your right to amend that petition diminishes over time. And if you get to a trial and you ask the court for relief, the first thing they're going to do is look in your petition and see if you've asked for that type of relief. And if you haven't asked for that relief in the petition, the court is not going to be permitted to allow you to seek it at trial. So that's why the filing of your petition is very important. Make sure you ask for everything that you think you might ask for in a contested trial, and keep an eye toward the matter being contested. And of course, hopefully the case will resolve by mediation. Hopefully both sides will be reasonable in the process. But when filing your petition, make sure you include everything that you could possibly ask for. Things that you're going to include in this petition are requests for alimony, if it's appropriate. There are all different manner of alimony that you can ask for depending upon the length of your marriage, and we'll get into detail about that as well. But some of the markers for your marriage and what you should look at are there's a 7 and 17 rule in Florida. If you've been married for 7 years or less, it's considered a short-term marriage. If you're married 7 to 17 years, it's a middle-length marriage, and more than 17 years is considered a long-term marriage. Depending upon the length of your marriage, you should tailor your filing of your petition to ask for an alimony amount if that's appropriate, based upon the number of years you've been married, the standard of living you become accustomed to during the relationship, and a bunch of other different factors that are listed in Florida statutes. It's Chapter 61. By the way, you can access Florida statutes online for free. They're available through any type of search engine, but Chapter 61 is the chapter under Florida statutes that governs dissolutions of marriage. Everything you need to know about dissolution of marriage is statutory based. Everything is spelled out in the statute as to the factors the court is going to look at in considering whether to award alimony, in calculating child support, in determining what assets are marital or non-marital, and determining equitable distribution of marital assets. Everything is written in there. It's relatively easy to understand from a legislative standpoint. But if you're representing yourself in any divorce action, you should read through Chapter 61 so that you're familiar with the substance of the law that applies to your action. In filing the petition, again, you want to ask for things that are applicable to your situation. If you have children involved in your divorce, you want to talk about child support in your petition. If you're the parent who you believe you're going to be the primary time-sharing parent with the child or children, you want to ask that a a child support amount be imposed upon the other party. Also a requirement in Florida, when you file a petition that involves children, you have to also attach to the petition what's called a parenting plan. What a parenting plan is it's a document that sets forth what you're asking for the court to award in the way of time sharing with the child or the children that you have. Again, the document is a form document. It's pretty easy to follow. It's a check-the-box document. It has multiple choice sections in it. It has narrative sections with blank lines if you want to ask for any type of special relief. And it's very, very comprehensive in the way of a format. It was tailored to be used simply by pro se litigants, and attorneys in practice use it as well. And it's a document that the court looks for to make sure that it's been filed. A parenting plan lays out excuse me, everything that you need to ask for in the way of time sharing with the minor children. It has holiday distributions between the parties. It has a standard visitation schedule if you want to implement a standard visitation schedule every other weekend. Typically, everybody asks me this, what's a normal standard visitation schedule in the state of Florida? It's a common question that people ask. Typically, the schedule is standard visitation schedule, which is now called time sharing. They don't call it visitation anymore. Is every other weekend, Friday after school, or for those working after work, until Sunday, whatever time the child or the children typically go to bed, about an hour before that, every other weekend. There's also a one-night visit during the week after school for a dinner typically, and that's on an every week basis, not an every other week basis. If the parties don't agree on what day it is, it's typically a Wednesday. And then the summertime is typically split in half. It's typically uninterrupted in my experience to allow both parties to have summer trips with the children that are uninterrupted. The holidays are also dealt with in a parenting plan where they split the time equally for holiday weekends, and depending on religious backgrounds and other determinations of what holidays you as a family participate in, those are split equally amongst the parents. Winter break, the way that a winter break is typically broken up is the day after the children get out of school for the winter break until a particular time on Christmas Day typically would be the first half of winter break, and then at that time on Christmas Day until the day before the children go back to school would be the second half of winter break. The way the courts typically deal with that is to flip-flop those two time periods to allow one party to have Christmas Eve and Christmas morning one year, and then the later part of Christmas Day through New Year's Eve and New Year's Day the alternating year. Spring break is typically either split in half or alternated on an annual basis, odd and even numbered years. And that's a typical standard visitation time sharing schedule that you can come up with here in the state of Florida. Of course, that's a standard time sharing schedule. Everything is negotiable. Of course, there's some people who don't exercise, particular holidays, who don't recognize particular holidays. Maybe some are important to others and not important to one. Everything is negotiable in that regard, and the parties can negotiate and come up with any time-sharing schedule that they feel works for them. Work schedules is also an important thing. There's a lot of people out there who work graveyard shifts. There's a lot of people out there who work, at different times. Some people work at, early morning hours. Some people work, 12-hour shifts 4 days a week, and they're off 3 days a week. A lot of the time-sharing schedule is driven by how many people are available to watch the children at particular times. So everybody's schedules are different, and the courts will look at that as one of the factors in a contested case to determine, where the child or children will reside at particular times. But that's the parenting plan. Parenting plan also addresses issues of where the children will be picked up, where they will be dropped off, who's responsible for picking them up and dropping them off. Everything is spelled out in there in excruciating detail. And it's an easy document to follow, but it's a requirement when you file a petition for dissolution of marriage, as well as a petition for paternity, that you file a parenting plan as well to address those issues, and the court will look for that. So keep in mind that that's a required filing. You also have to include in your filing for paternity and for divorce allegations under the UCCJEA. The Uniform Child Custody Jurisdiction Act requires that the court be advised where the children have lived for the last 5 years. It's a requirement in order to make a determination by the court that Florida, or wherever you're filing, whatever state you're filing in, has sufficient contacts with the child that this is actually the home state for this child. And you have to allege in there if there's been any other cases involving the children. You have to disclose that to the court when you file, so that the court's aware. For instance, if you filed a paternity action before, the court needs to be aware of the case file number, where it was filed, and all that. In addition, if you filed for divorce previously and dismissed the case, that's something you should disclose to the court as well. A lot of times that happens where parties reconcile and end up not getting divorced and dismissing the case. You should disclose that case to the court if you refile for dissolution of marriage. The court previously required you to file notices of Social Security numbers with the court. In my experience, the courts no longer require you to do that, and I discourage you from filing a notice of Social Security number with the court for obvious reasons. You want to keep your Social Security number secure to you and not file it in a court filing. You may be required, of course, in the course of the proceedings to disclose that, but in most instances, you're being married to the other party. They know what your Social Security number is already. Other than that, when you file a petition for divorce, you have to also have a summons issued from the court for the petition. The summons is the call to action to the respondent, who's the person you're suing in the petition for dissolution of marriage, to have to respond to the petition within 20 days. The petition, the summons, your parenting plan, and also a financial affidavit, which you're required to file with the court, all have to get served personally on the respondent, your husband, your wife, the father, the mother. And then that person, after being personally served, has 20 days to answer. This is not a situation where you can mail it to the other side. It's not a situation where you can email it to somebody. It actually has to be served by a process server or a sheriff upon the other party. So keep that in mind if you're filing pro se. If you hire an attorney, these are things your attorney handles for you automatically. It's not anything you need to be concerned about doing. There is a filing fee when you file for divorce here, and it's a little more than $400. For those of you filing, you need to keep that in mind, because it's a substantial cost in the process, is the filing fee. Also, if you're having the summons and the petition package served on the other party, there's a fee that you have to pay the process server as well. Those range depending upon how quickly you want the other party served. They could range from $40 to $50 to $60. If you want it expedited, it could range from $70, $80, $90 for an expedited service. So you have to keep that cost in mind as well. I mentioned that you have to file what's called a financial affidavit with the court. This is the one financial document that you absolutely have to file in every divorce case and in every paternity case. The reason being, the court needs to be aware of what your income is, what your net income is, what you pay for health insurance, what you pay for health insurance for the minor child, if you have union dues, what you pay for your union dues, because all of these things factor into what your net income is. And your net income factors into what your child support is going to be. And your net income also factors into the extent that it's applicable to your situation, what the alimony in the case may be. Both parties have to file a financial affidavit. A lot of people ask me, am I required to do that? Or can we both agree not to file those? No, you can't agree not to file those. You absolutely have to file those. The court will not allow you to get a divorce, will not allow you to get a paternity determination without filing financial affidavits with the court. There are two different forms of financial affidavit that apply here. There's one if you make less than $50,000 a year gross, and one if you make more than $50,000 a year gross. One is called a short form, and one is a long form. Of course, the longer form is if you make more than $50,000 a year. If you're filing pro se, make sure that you file the appropriate form when you file your action. Again, if you have an attorney handling this, your attorney will forward you the form to fill out, and you fill that out and send it back. The absolute rule of thumb of what you need to do when you file that financial affidavit is be honest. You're swearing to the document. It's a notarized document. It has your signature on it. It says that you swear or affirm that the information contained in it is true and correct to the best of your knowledge. And it's the one document from a financial perspective that you file with the court. Be very careful filing a financial affidavit. You must include everything on there as of the date you prepared the document. If you're making a certain amount of money as of the date you prepare the document, that's what you put down. If you anticipate that you might make more money or less money in the future, don't put down what you anticipate you're going to make, because the date that you sign that document is crucial if you should proceed to a contested case, if you should be questioned at a deposition or questioned at a trial. The information that you put on that document could lead to you appearing to be misleading to the court if you fudged the information on there. So be very careful. It's the one document that most attorneys, it's the first financial document they'll see, an opposing attorney. And if you haven't had the opportunity to see a situation unfold like this, if you have a financial affidavit that's been filed that contains false information or contains information that's not there at all, it's misleading, it's an opportunity for opposing counsel to tear you apart on a financial affidavit and make you look like a liar. So be very careful in filling that out. Fill it out honestly, fill it out completely, and don't anticipate what might happen in the future in filling it out. Fill it out as of the date you fill it out honestly. If your circumstances change from week to week, month to month, or unfortunately in cases where your case goes on for more than years, from year to year, you can always file an updated or amended financial affidavit as your circumstances change. So don't feel like once you file this document that you're never going to be allowed to change it, or I have a lot of people who come in and say, this is what I'm making now, but my boss told me I'm going to get laid off 2 months from now, or business is slowing down and I'm never going to make this money in the future. Put down what you're making as of the date you prepare and sign the document, and if things change, do an amended financial affidavit as soon as your circumstances change to reflect any downward reduction in your pay. The documents, the financial affidavit is important because it drives what your child support is going to be. So even a $100 difference in a weekly calculation could equate to an awful lot of child support that you may not be obligated to pay. So be very careful when you prepare the document. Your attorney will advise you, if you have one. If you don't have one, how to calculate what your income is. A lot of people have their own businesses, and it's hard to calculate what their income is. The financial affidavit requires, if you have your own business and you're paying yourself, that you attach to the financial affidavit a profit and loss statement of gross income that you made, and then detail of the expenses you incurred, and then sort of a net calculation of what your income is over a period of time. Be sure to attach that if you're self-employed. A lot of people also have jobs that are sporadic. They get some income for 2 weeks out of the month, and then 2 weeks out of the month they don't make anything. What you should look at, and by way of example, we're in June right now, a way that I'd encourage somebody to calculate their income is I'd ask them, well, what did you make in 2013? They tell me what they made in 2013. And then I say, well, what did you make year to date now? They tell me what they made year to date now. And then I come up with some type of average of what they made last year and what they're making now to come up with some amount that we can put down as a monthly income. Because in all fairness, if you've made year to date a certain amount of money, and right now there's 5 months that have passed, and you divide that by 5, it should be a pretty good indicator after 5 months of what you're going to make on a monthly basis over the year. So that's the best way to calculate for those people who don't have a regular job where they make an hourly wage and they work 40 hours a week or less than that. Again, with calculating income, if you do make an hourly wage, you should look at what hours you're getting in the present time. And a lot of times that's hard to calculate, and it's a judgment call what you need to put in your financial affidavit. Confer with your attorney about that and find out what you think you should put down on an average. A lot of people come in and they tell me, well, I make $12 an hour, but I only got 24 hours last week, and the week before I got 30, and the week before that I got 37. It's all over the board. Again, taking averages, over the past 5 months, for instance, we're in the first week of June here, will help to give you an appropriate amount of income to put down in your financial affidavit after 5 months. Again, if it turns out that things drastically change, you can always file an amended financial affidavit after that. As far as filing your petition, that's what you need to file from a divorce perspective. Your petition for dissolution of marriage, your parenting plan if you have children. If you don't have children, you don't have to file that, of course. Your summons, your financial affidavit. There's one last thing you need to file, and that's called a civil cover sheet. A civil cover sheet is a way that the court handles calculating statistical information for the court system, and it advises the court what type of case you're filing. It's required in every case on the civil side, in circuit civil, and you'd simply check the box that says it's a dissolution of marriage proceeding or a paternity proceeding, depending on what you're filing. Other than that, you just sign it, date it, you put the style of the case, which is Amy Smith versus Bill Smith, and the case number on it, and you go ahead and you file the entire package that way. Again, you have to serve the other party with it. They have 20 days to respond, and then you see how they're going to respond to that. On the other side of things, a petition for paternity, very similar. You file a petition for paternity. You file a parenting plan, because obviously with paternity there's children involved in every case. You file a civil cover sheet and a financial affidavit, and you get the summons issued and serve the package that way. So a very similar process in that regard. Oftentimes people hire attorneys to file family law matters, and then they discover that they have problems with their attorney. Happens more times, oftentimes in family law matters, because of the relationship involved. When we come back from the break, I'm going to talk about changing attorneys, hiring attorneys, substituting attorneys in after the fact, and we'll be back right after these messages.
Attorney Sean Shepard has been practicing family law for 18 years, and he is in good standing with the Florida Bar Association. Attorney Shepard is licensed to Florida, New York, and New Jersey. He is a trial attorney with his primary practice in the area of family law litigation. He has handled thousands of cases and hundreds of contested trials before both judge and jury. Attorney Shepard is a former judge, advocate, general court officer from the United States Navy, and therefore possesses a wealth of knowledge regarding military-specific issues to divorce and other family matters. Attorney Shepard not only handles matters from intake through trial, but he also handles all matters of post-trial and appellate work. His unique background has enabled him to develop a keen insight into all aspects of family law litigation, from beginning to end. If you or a family member are about to go through a divorce or have other pending family law problems, contact attorney Sean Shepard today at 954-632-0668. Let attorney Shepard give you sound advice and fight for your rights. Offices in Fort Lauderdale. Call them today to make an appointment. 954-632-0668. You are listening to the South Florida Family Law Show with attorney Sean Shepard, bringing you all the answers to the questions you have about family law. Join the conversation at 888-565-1470. Now, back to our show.
Welcome back. During the break, we had a few tweets that came in. I'm going to read through those and try to answer those the best I can. Joe from Boca wrote in, can a divorce agreement be changed because your financial circumstance has gotten better or worse? It's a good question. It depends on the agreement. If the agreement has, for instance, an alimony provision that's modifiable, you certainly can get a modification to that. What you need to do to get a modification to an agreement, again, if it's modifiable, and it'll say in there whether it's modifiable or non-modifiable. If it doesn't say, then it is modifiable. So if it's silent on the issue, then it is modifiable. But if, for instance, you have a situation where you entered into a mediated settlement agreement and you agreed to pay alimony over a period of time, and then 6 months later, a year later, your financial circumstances change and they've gotten worse, which is the typical situation, you can then file what's called a supplemental petition to modify. A supplemental petition to modify enables you to demonstrate to the court that there's been a substantial change in circumstances. I lost my job, I got hurt, I can't work anymore, my hours got reduced. But it has to be a permanent change in circumstances. So, for instance, if you got hurt and you were off the job for 2 weeks and you came back and you got the job back, that's certainly not a permanent situation. But if you got laid off entirely, or as we've all suffered during the financial downturn, if there's been a financial change in circumstances just from economic changes, if you're self-employed or otherwise, and you've realized the loss that you're not coming back from, you can certainly file a supplemental petition to change things. And I spoke briefly about this last week, but it's very important that if you realize a change in circumstances has hit you, that you don't sit back and wait too long before you file that supplemental petition, because the relief you're going to get, if you're going to get it at all, is going to date back to the date you filed that petition. So if you, hypothetically, if you're making $5,000 a month and you're obligated to pay alimony, and all of a sudden your hours get cut and you're making $3,000 a month instead of $5,000, and you think you're going to come back from it, you think perhaps your hours will pick up again or the economy will pick up again, and you wait 90 days, 120 days, 6 months, a year, and you're still making $3,000 and you're not making the $5,000 when you agreed to it, and you just sit back and you don't file anything, that accumulation of whatever alimony or child support or whatever you're paying is going to continue to accumulate against you, and you're not going to be able to go to court a year later and say, well, a year ago I lost $2,000 a month in income and I haven't come back from that. The court's not going to care. The date of your filing is the date from which you get your relief. So be very careful in that regard. If you have financial circumstances that have changed, file immediately once you realize it's a permanent change in circumstance, so you can get your relief happening as quickly as possible. Good question. In addition, if you're on the receiving side of alimony, and perhaps at trial, and this happens a lot, at trial, people go in and they ask for alimony, and the judge bases alimony on financial need and ability to pay. Those are the two biggest factors the court will look at. They'll say, okay, does this party have a need for alimony, and does this party have an ability to pay the alimony? A lot of times, in a lot of cases, the court will find that the party in need has a need for alimony, and they'll put a number on it. They'll say this party has a need for $4,000 a month in alimony, but they'll find that the other party only has the ability to pay $2,000 a month toward that need. If you find that the other spouse is subsequently making a lot more money than they were back at the time you mediated your settlement agreement or you got a final divorce decree from a judge after a contested case, you can file a supplemental petition to increase the alimony because you already have a need established for that alimony. And now that time has gone on, perhaps the other party has paid off some debts or is making more money on their job, you can seek an upward modification of your alimony to allow you to get to the financial need that was established already. So keep that in mind from both sides for purposes of filing. And again, the same rule applies. If you know that there's been an increase in income on the other side, or that the other party has paid off a lot of debt and they have a lot more available income to pay you alimony with, you're only going to get that upward modification from the day you file your petition. So waiting to file your petition, you're losing money every single month if the court ends up granting you relief, because they can only grant you relief back to the date you file your supplemental petition. Another question came in, Mary from Delray says, can you limit a spouse from taking children outside the state even if the other party's job requires it? And the question is a little bit vague. I'm presuming this is a permanent move and not just a temporary move. Follow up with a question if I'm not addressing this properly, but anticipating that that's a permanent move out of the state. In order to move a child out of the state of Florida, that the legislature created a statute that requires that the spouse seeking to move, or ex-spouse seeking to move a child out of the state of Florida, to file a petition with the court asking for permission to move out of the state. Before they file that petition, they have to send you a notification saying, I intend to file a petition to move out of the state, and you can consent to it at that point if you want to consent. If you want to object to it, you have to notify them that you're objecting to that. If you object to that, they have to file a petition with the court to ask for permission to move outside of the state of Florida. The court, in determining whether to allow that move to happen, will look at all different factors. And if you're trying to defend against that, you want to show that there's no need for that ex-spouse to move the child out of the state of Florida because there's plenty of jobs here, for instance. However, there's some people who, particularly in this job market, who can bring in testimony and experts and vocational experts that come in and testify that that particular person's job, what they're qualified to do, there are no jobs here in Florida for that person, and the only jobs available that are paying the money that they're seeking are out of state. And that becomes a battle in court, and it happens a lot, and there's a lot of emotions involved because obviously moving a child away from a parent it's a horrible thing. But unfortunately, there's a lot of situations financially that require moves of that kind to happen. But the answer to the question is yes, you can limit a spouse from taking a child outside of the state of Florida for a job, but you have to go to court to try and do that if the other party's not willing to agree to that. And the court will require the party seeking to relocate the child to prove why they're moving, and it has to be a legitimate move. It can't be simply to interfere with the other spouse's rights, ex-spouse's rights to visit with the child or the children. It has to be for some legitimate purpose. And there are specific requirements for filing a notification and a petition to relocate, and there are objections you need to make if you're opposing that. So keep in mind that there are strict time limits you need to follow in order to do that. A lot of times, and I have this situation come up a lot, particularly now when there's a lot of people out of work and they're applying for jobs in California and Texas and everywhere where they can try to get jobs. A situation will come up where you have one parent who's the primary time-sharing parent and the other parent who's the secondary parent who has less time sharing with the child or the children. And the primary time-sharing parent gets a job in California and they have to start in 2 weeks. Of course, ideally you want to keep in communication with the other parent, but a lot of times that's difficult due to different dynamics involved in the relationship. But I always encourage everybody to be as transparent as possible in letting the other parent know, I'm applying for a job in California or Texas and I've had a hard time finding a job, but I'm just letting you know, and keeping those communications by email or text so you can show the court that you've made every effort to try and be reasonable. But a lot of times, from a practical perspective, you don't have time to seek permission. You don't have time to file the petition. And oftentimes, there's a situation that arises where the job has to be taken, and a move has to be made, and you're still filing a petition back in Florida to try and get permission to do that. And it happens a lot. And there's no real remedy to it other than to move as quickly as possible and trying to get the court to hear your petition, and trying to work as reasonably as you can with the other parent to accommodate what they're requesting of you. So keep in mind that there is a formal petition requirement, and there are requirements by the statute that you have to follow. Paula in Orlando had a question. It says, what questions should one ask when meeting a new attorney, making sure that you and the attorney are both on the same page? And Paula, you must have been reading my mind, because I wrote a note to talk to you all about that today. Questions you need to ask a new attorney. And a lot of this is available. You can go on FLABAR, it's FLABAR.org, which is the Florida Bar website. And before you meet with any attorney, you should, get the full name of the attorney, go on the Florida Bar website, look up the attorney, and you'll see on there some just basic information about the attorney, how long they've been admitted to the bar. There's also a 10-year disciplinary history on the attorney that you can look at there, and if in most instances attorneys don't have a disciplinary history, but in some instances they do, and you can actually look at that history online. That's available to the public. So look at that first as a first step in the process. You can also go online. There are a number of different sites that publish information regarding attorneys. Avvo.com, avvo.com is an attorney review site. It's pretty prominent on the web. Lawyers.com is another one. And you can go online and do search engine searches for the name of your attorney to see if there's anything out there negative or positive about the attorney before you go and meet the attorney. Keep in mind that not all the information on the web is accurate, but you certainly have it at your disposal and can ask the attorney questions about it. Print it out, bring it in and ask the attorney and confront the attorney about it. If you had somebody who had a negative review about the attorney, perhaps bring it in and ask him what happened, him or her. You should also ask the attorney whether they specialize in any area of the law, whether they're board certified in any area of the law. You should ask the attorney most critically if they've tried any cases. There's a lot of attorneys out there who haven't tried cases. Ask the attorney if they've tried cases in front of the judge that you have, if you know what judge you're going to have at that point in time. Attorneys should be able to answer these questions for you. Anybody who pushes back on questions that you ask them about them, or gets offended by questions you ask about them, is probably not the attorney you want representing you. There should be a transparent situation where they're willing to give you credentials. Typically, you're paying your attorney hundreds of dollars an hour, and if the attorney's not willing to answer questions of this basic kind of you, and they're demanding that you pay them hundreds of dollars an hour, it's probably a different attorney you want representing you in the process. So they're there to answer your questions, and you should ask them to do that. If anybody appears uncomfortable with you asking those questions, it should send a red flag up for you that perhaps there's something there that they don't want you to know about. So good question. My notes, one of the things I wanted to talk about, and this happens an awful lot with situations where people come to me after they already have an attorney, and they say, Sean, I feel like I'm fighting with my own attorney to ask for the things I want to ask for, or I'm trying to convince my attorney why I should win my case. If you're doing that, if you're fighting with your own attorney about asking for the things you want to ask for, you need to get rid of your attorney and get a different attorney. If you can't convince your attorney to be your mouthpiece and ask for the things that you want to ask for, subject of course to reasonable discussion, you need to get a different attorney to do that. And it happens a lot. There's a lot of people who go in and meet with attorneys, and they get into arguments with their own attorney about things they want to ask for that the attorney doesn't want to ask for. And that's certainly not a situation you want to be in. You and your attorney should be aligned with one another on what you're asking for. You should both have the same passion about what you're asking for. And if you don't have an attorney who's willing to do that for you while you're paying them to do that for you, you need to get a different attorney. Now, with that said, there are situations where some people ask for things that are absolutely you're never going to get. And the way that those situations are handled, the way that I handle them, is I'll advise the client, look, this is something you want to ask for. I'll show them the case law or the statute that says that it's very unlikely they're going to receive that if they contest it at trial. I'll counsel them as to what I think is going to happen at trial. And if they still want to move forward and they want to ask for those things nonetheless, I'm 100% on board with what they want to ask for. That's what your attorney should do for you. He educates you about the process. He tells you what he thinks the chances are that you'll prevail with a particular argument. But in the end, it's your decision whether you want to proceed with claims or not proceed with claims. And it's your attorney's obligation to be your voice box for that. If your attorney doesn't want to do that and wants to fight you and not ask for the things you want to ask for, you need to get a different attorney. Getting back to the issues we were talking about the nuts and bolts of filing a petition for divorce or petition for paternity. We talked briefly about filing a financial affidavit with the court, and I said that's the one thing you have to file with the court from a financial perspective that neither party can waive. There's one other aspect to financial disclosures in divorce cases that everyone needs to know about in contested cases. And there's a rule called Rule 12.285. And what Rule 12.285 is a required rule in any divorce case that parties exchange a list of documents. And contained within that rule is a requirement that both parties exchange these documents during the preliminary parts of a divorce case. Now, the parties can agree to waive this requirement. Unlike the financial affidavit, they can't waive. This they can agree to waive. But if they don't, both parties have to exchange these documents. These documents include bank statements, tax returns, retirement account statements, investment account statements, deeds to property that they're on, lease agreements that they're currently on, promissory notes of people who owe them money, safe deposit box disclosures if you have safe deposit boxes. It's a standard required financial disclosure for both sides of a divorce transaction. And in most instances, if a case is contested, even the initial preliminary stages, those documents will be exchanged between the parties. But again, you can waive doing that. What it does and why it was created was to allow both parties to have a general idea of the financial situation of the other party so that they knew what they were getting into. And it's in all fairness, it allows both parties to a divorce to understand the full financial circumstances of the other party. If there are any bank accounts out there that another party didn't know about, any safe deposit boxes out there that the other party didn't know about, this rule was created to allow both parties to have a full understanding of what financial circumstances the other party are. And all of these financial records and all the financial affidavit filings come into play for purposes of obvious reasons for child support and alimony determinations by the court in a contested case, or at mediation, so that you know what you're dealing with when you negotiate a case through mediation. There are also, in fully contested cases, under 12.285, those are the documents that are required to be disclosed between the parties if they're not waived. In fully contested situations, you can ask for what's called a request for production. And this is your opportunity if you want to ask for things above and beyond the standard financial document disclosures. You can ask for those things. You can also take a deposition of the other party and ask them questions under oath about certain things. In divorce contexts, one of the things a lot of people ask me is, if the other party had an affair in the divorce or had a relationship that was with another party during the marriage, if that's relevant or anything, or can I bring that up during the divorce? you certainly can bring that up during divorce, even though it's a no-fault state. The statutes here in Florida allow that to be a factor for consideration in an award of alimony. For instance, it could be a factor in consideration in award of attorney's fees for the case as well, and can be a factor in consideration to the extent that the other party spent money on this affair that they had with somebody else. So it is relevant in that regard. So to the extent that that is a situation that's involved in your divorce proceedings, it's certainly something you want to bring to the attention of your attorney, and certainly something, if you're representing yourself, that you're entitled to ask questions about, because it could potentially come up in a contested trial. One of the things you also have to consider is when you're filing for any divorce proceeding is attorney's fees, if you want to seek attorney's fees in the divorce case. That's certainly getting back to the filing of your case. Even if you're representing yourself pro se in the case, you may later on in the case determine that you want to hire an attorney to represent you for the trial or other aspects of it. When you initially file your petition pro se, you may not ask for attorney's fees. If you do hire an attorney later on in the process, you want to certainly ask for an award of attorney's fees if you're in an inferior position from a financial perspective. In every divorce proceeding, the court has jurisdiction and has discretion to award attorney's fees to one party or the other in a case, and that depends in large part on the financial ability of one to pay it and the financial need of the other for it. So keep that in mind as well, because attorney's fees in these cases can add up tremendously as time goes on. We'll be back next week, the same hour, 5 to 6 o'clock on Friday. Enjoyed being here today. I've enjoyed the questions. Thank you for tweeting those in, and look forward to next week answering any questions you might have. Again, it's Sean Shepard. I appreciate your time today and look forward to talking to you next week. Thank you.
Thanks for tuning in today to the South Florida Family Law Show with attorney Sean Shepard, with offices in Fort Lauderdale. If you would like to set up an appointment with attorney Sean Shepard, call his offices at 954-632-0668. And tune in again next week for another South Florida Family Law Show with attorney Sean Shepard. And let Sean answer your family law questions. The opinions expressed on the preceding sponsored program were strictly those of its hosts, guests, and callers, and not necessarily those of this station, its staff, management, or sponsors.